Our next guest says the banks aren't likely to get far in court. Harvard law professor Laurence Tribe joins us now from D.C. And thanks so much, Professor, for being with us.
My pleasure.
And I just want to explain to our viewers, I mean, what we've been talking about here is the financial lobby hiring this guy, Carter Phillips, an experienced lawyer. He's argued many cases before the Supreme Court, arguing that this tax is essentially unconstitutional. And you say that that's not going to fly.
Not going to fly. I know Carter. He and I worked together on a number of cases. But it takes more than good lawyering to make a constitutional silk purse out of this sow's ear. This is a constitutionally invulnerable tax. To begin with, nobody that it hits can claim unfair surprise, can claim to be shocked that Congress is trying to make taxpayers whole, because the statute that created the TARP program specifically required the president by the year 2013 to propose a plan for closing the hole that this TARP would leave, and the $117 billion is simply going to be collected back. The other thing is that the power to tax includes the power to draw lines, and that's what essentially these guys are complaining about, that it hits only the biggest banks. Well, there's nothing wrong with exempting smaller banks, with exempting auto companies, with exempting Fannie Mae and Freddie Mac. It's nothing like the so-called bill of attainder, which some people have compared this to. A bill of attainder singles out specifically identified individuals and companies for punishment.
So you're saying that if the White House went and said, we're going to put a tax on Bank of America, we're going to put a tax on Citigroup specifically, then that would be unconstitutional?
Well, that would certainly be much closer case. Probably if they said Bank of America is going to pay a punitive tax, that would be unconstitutional. But even there, the Supreme Court is very hesitant to treat taxes as punishments, as equivalent to fines. But this doesn't even raise that question, because this law sets out general criteria. It is limited to people, entities with contingent assets and certain kinds of assets above $50 billion. And it targets specifically liabilities in order to put pressure on people not to over-leverage. So this is about as invulnerable a tax as I've ever seen.
But surely they must, the financial lobby must think they have some sort of legal basis. And Professor, I mean, is there any limit at all, for instance, that they could place, or they could argue that there should be at least some sort of limit on these taxes?
Well, it's always a good investment to hire a very good lawyer to look at something. I'm not criticizing them for that. I don't think their shareholders will complain. But I'm just telling you, you could save a good bit of money by just reading the Constitution and the precedents. There are limits. Congress can't suddenly tax somebody into oblivion retroactively, ex post facto. But there's nothing ex post facto about this. It's a tax on current assets and liabilities, and it's based on a statute that said that the people who are bailed out should expect Congress to come back looking for the money to make taxpayers whole. And that's exactly what this does. So whatever the limits are on the taxing power, they're not even approached by this law.
Professor, we just only have a little bit of time here. I mean, can the lawmakers, though, would they be tempered, though, by this threat that this is a case that could be brought before the Supreme Court eventually?
No, if lawmakers were worried that whenever lawyers might go to court, they ought to start shivering in their boots, we would have an even more paralyzed legal system than we do right now. I don't think anybody is going to be fooled by this threat.
Well, paralyzed legal system is certainly something that we can possibly all agree on. Thank you so much, Professor.